Hello, everyone. My name is Ben Massey, and I'm the president of the University of Virginia chapter of the Federalist Society. I'd like to welcome you all to Charlottesville and the University of Virginia School of Law. Thank you so much for coming to the 30th Annual Student Symposium. This year's symposium is entitled Capitalism, Markets, and the Constitution. The speakers participating in the various panels and debates over the next 2 days will explore the connection between the markets, economic liberties, and the Constitution, as well as the role of the courts in this important issue. Following today's debate and panel, we will have a reception in Kaplan Pavilion, so I hope to see all of you then. As a reminder, please do not forget to wear your name tags for all symposium events, especially the banquet. Your name tag is your entry ticket for all symposium events. If you have any questions during the symposium and your stay in Charlottesville, the members of both the symposium committee and the chapter executive board are happy to help. You can identify us by the green leadership ribbons on our name tags. All right, with the preliminaries out of the way, let's get started. First, with some opening remarks, we're pleased to have with us today Professor Lillian Bevere. Professor Bevere is the David and Mary Harrison Distinguished Professor Emeritus here at UVA. A graduate of Smith College and Stanford Law School, Professor Bevere taught at the law school from 1973 until her retirement last year. She is also on the Federalist Society Board of Visitors and served as the UVA chapter faculty advisor from its founding in 1983 until last year. Without further ado, Professor Bevere.
Thank you, Ben. This was supposed to be the dean of the law school, Paul Mahoney, who welcomed you. It's not that I don't welcome you, it's just that he's a little bit more important than I am. But his son it turns out to be the best basketball player that has ever lived or played basketball at Tandem School. He's the absolute star of his high school team. He scored the most points, blocked the most shots, garnered the most rebounds of any athlete in the history of the school, and he's being honored tonight on the occasion of his last home game, which was originally scheduled to take place last night, but was rescheduled tonight so as to conflict with the Federalist Society. His father decided that it was his duty as a father that took precedence over his obligation to be here tonight, and he also wanted to honor his son, and I think we can all understand and sympathize with that, and indeed take pride in that, in the priority that he set for himself. He'll be with us tomorrow at 4 o'clock for the panel on economic uncertainty and the role of courts, and of course he'll be at the banquet tomorrow evening. So here we are, gathered at the 30th Annual Federalist Society National Student Symposium. Is it not wonderful to think that this is the 30th National Student Symposium? Perhaps for you, it's not surprising that we are at the 30th. Most of you are, many of you at least, are not even as old as the Federalist Society is, so you think 30 is pretty old. You also probably think that the Federalist Society is just a permanent fixture of the legal landscape, something that just is and always has been. You may not even be able to imagine what law school would have been like or what law study would have been like without the Federalist Society. So it may seem to you that this is just part of the nature of the legal landscape that the Federalist Society exists, and although it's a young organization, relatively speaking, it certainly has, it is a natural feature of the world as we know it. But it wasn't always so. Indeed, in the beginning, the Federalist Society's future was more than a little precarious, or at least it apparently seemed so to me. I was a panelist at the 4th Student Symposium at Stanford University in 1986. And as a group of us were sitting around at lunch on the Saturday of the symposium, Jean Meyer has reminded me that I opined in my very confident way, you know, this is a great organization. It's just too bad it can't last. Oh, I was of little faith. So what accounts for the fact that the society has not merely survived for 30 years, but that it is thriving and will continue to thrive? Now, one factor, surely, is the power of the principles on which the society is founded. You know what they are, that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. But there's a second ingredient to the success of the society that bears us being reminded of at a time like this as we begin this symposium. And that is that the Federalist Society has provided a forum for debate, for genuine and civilized debate about ideas, debate that joins issue, debate that doesn't indulge in name-calling, but that encourages participants to express ideas from all parts of the political and philosophical spectrum. I think it's the combination of these principles that the Federalist Society embraces and the forums for debate that the Society provides that has accounted for its success to date and that promises to secure its future. It's also, of course, the enthusiasm and interest of wonderful student symposium attendees like yourselves. We're very glad to have you. As Ben has said, and as you know, the topic of this year's symposium is capitalism, markets, and the Constitution. This could not be a more timely topic, nor would it have been possible to find a topic as susceptible to, or indeed as in need of, the kind of genuine and informed and balanced debate that is the Federalist Society's trademark. Our students at Virginia here have worked very hard to make the symposium a success. Looking at the program, it's very clear that the panels are going to address the most relevant and interesting questions. It's also clear that the students have enticed a wonderfully well-informed and engaging group of scholars and judges to address the issues. It's going to be up to the panelists, of course, as well as to us in the audience, to make sure that the symposium remains faithful to the Federalist Society objective of sponsoring the event, namely, to make sure that the participants engage the issues and that all of us listen to and respect all the points of view that are expressed here. Now, in addition to putting together a truly terrific group of panelists, the chapter here has worked very diligently all year to identify everything that needed to be done and to attend to the myriad of details that are involved in putting on an event such as this. What they wanted to make sure of was that you are comfortable the whole time you're here, that you're well-fed, and that everything runs like a well-oiled machine in true Federalist fashion. What the organizers have tried hardest to guarantee, and what all of us here at the University of Virginia Law School want, is for everyone to have a stimulating, challenging, thought-provoking time. Above all, we want you to have a spectacularly good time. So without further ado, I say once again, welcome, and let's get on with the show.
Good evening. My name is Devin DeBacher, and I'm one of the speakers and panel's vice chairs. On behalf of the Federalist Society, I would like to welcome everyone to the debate on economic freedoms and the Constitution. I have the undeserved privilege of introducing the moderator for tonight's debate, the Honorable Deborah Livingston of the United States Court of Appeals for the Second Circuit. After graduating from Harvard Law School with honors, she clerked for Judge J. Edward Lombard on the court to which she would later be appointed. Following her time as an associate in the New York office of Paul Weiss, she served as assistant U.S. attorney in the Southern District of New York for 5 years before becoming deputy chief of the criminal division, of appeals in the criminal division. Around that time, Judge Livingston then elected to pursue an academic career. After 2 years at Michigan Law School, she joined the faculty of Columbia Law School and eventually served as vice dean. Before being appointed to the Second Circuit in 2007, she co-authored a leading case book on criminal procedure and taught courses in evidence, criminal law and procedure, and national security law and terrorism. Without further ado, please join me in welcoming Judge Livingston.
Thank you for that kind introduction. I am very happy to be here today and to have the privilege of moderating tonight's opening event, a debate on economic freedoms and the Constitution. We have a great topic and two articulate and extremely thoughtful advocates. I predict that tonight's opening debate will be a very serious and helpful framing of many of the issues that this symposium will be exploring. Let me take the opportunity to say this debate is made possible by the generosity of the John Templeton Foundation, for which the Federalist Society thanks them. It has been the conventional wisdom of constitutional scholars that the Supreme Court went seriously off course during the Lochner Era from about 1890 to 1934. As one such scholar put it in 2005, the Lochner Court's protection of economic liberty at the expense of social welfare legislation has been deplored by constitutional scholars across the political spectrum. And in the years since the end of this famous period, the Supreme Court itself would seem to have agreed with the scholars, at least judging from its withdrawal from rigorous scrutiny of legislative action in many economic areas, whether such action be by Congress pursuant to the Commerce Clause or by state legislatures. Tonight's debate will not focus narrowly on whether Lochner was correctly decided, though both of our debaters in their writings have suggested ways in which they think Lochner's conventional critics may have, at least in certain ways, missed the mark. Instead, tonight's debate will take up broader questions that often underlie scrutiny of the Lochner era, such as whether our Constitution places meaningful, enforceable limits on the regulation of economic activity, and whether it is desirable for a Constitution rigorously to constrain the power of the state in regulating the economy and redistributing wealth. You will not be surprised to learn that Professor Barnett, author, among many other things, of What's So Wicked About Lochner, will challenge some conventional views on this matter and argue that the original Constitution, together with its amendments, provided for the robust protection of economic liberty. Indeed, that this Constitution may be the most explicitly libertarian governing document ever enacted, and that judges measured by this standard have erred in its interpretation. He will be followed by Professor Rosen, who will defend a more traditional view, at least judged in light of contemporary constitutional scholarship, of both constitutional authority and perhaps even more importantly to his argument, judicial competence to intervene to protect economic liberties in the modern era. So after each of them has spoken for about 10 to 15 minutes, we'll have time for some back and forth between them before we open the floor for what I'm sure will be a lively set of questions. We are fortunate indeed to have these two in particular to take up this opening debate. Professor Barnett, the Carmack Waterhouse Professor of Legal Theory at Georgetown, is one of the country's leading constitutional theorists. He is the author of over 90 articles, 9 books, including Restoring the Lost Constitution, The Presumption of Liberty, which has been described by reviewers as a bold defense of the theory of originalism and the most detailed, cogent, robust argument yet provided for a libertarian reading of the Constitution. The same year that Princeton University Press published Restoring the Lost Constitution, you'll be happy to know that Professor Barnett furthered his preparation for tonight's debate by arguing a certain medical marijuana case with which we are familiar before the United States Supreme Court. Professor Barnett is a graduate of Northwestern University and the Harvard Law School and a recipient of a Guggenheim Fellowship in Constitutional Studies. We are privileged to have him here. We are similarly lucky to welcome Jeffrey Rosen to this debate. Professor Rosen teaches at George Washington University and is the legal affairs editor of The New Republic. The LA Times has aptly termed him the nation's most widely read and influential legal commentator. A true polymath, Professor Rosen is the author of numerous books and countless articles spanning not a few but very many fields of law. His most recent book, The Supreme Court, The Personalities and Rivalries That Defined America, has been described as a fascinating insider's perspective on the court and the contrasting personalities who have shaped it. The Naked Crowd, another Rosen book that I've often had occasion in my own field to discuss in class, has been praised as adding much-needed depth to the debate over balancing privacy and security in the post-9/11 world. Professor Rosen is a Marshall Scholar, a graduate of Harvard University and the Yale Law School. We welcome him as well. I will sit down. Let me just make one announcement before I do. By now, each of you should have received a copy of a double-sided questionnaire on yellow paper that should have been included in your registration packet. And it was also handed out at the beginning of the debate at the entrance. We have allotted time following the debate tonight and before the next event for you to complete that questionnaire. And I've been asked to alert you to the fact that the information you provide on the questionnaire is extremely valuable to the Federalist Society. The survey only takes 5 to 10 minutes to complete. All of your responses remain anonymous, but it is helpful to them in improving their programs and working to put on the wonderful events that they are so well known for. With that said, the debate is ready to begin. Professor Barnett.
Thank you, Judge, for that wonderful introduction. Thanks to the Federalist Society for inviting me to be here tonight. I always enjoy and I always accept invitations to speak at the National Student Symposium. It is the highlight of the Federalist Society season. It is the most interesting and provocative event that the Federalist Society has ever held, and it is responsible, as I'll mention in a minute, for why I teach constitutional law and why I do constitutional law. Well, it's my job tonight to defend the proposition that the Constitution of the United States protects economic liberty. Now, if you've read your program, you see there's a very long list of questions. Don't open it up now. If you see there's a very long list of questions that this panel is supposed to address. But when I was invited to debate, I was invited to debate on the proposition of whether the Constitution protects economic liberty. So that's how I defined my talk along that narrow description. Does the Constitution protect economic liberty? And I only have 15 minutes, so I'm not going to venture far afield into the areas of, for example, is the Constitution a libertarian document, and was Lochner versus New York correctly decided? So let me clarify the issue as I see it by defining what I mean by economic liberty, or what is meant by economic liberty. I define economic liberty as the right to acquire, use, and possess private property, and the right to enter into private contracts of one's choosing. Now, if these rights are protected by the Constitution, then we can conclude that the Constitution does protect economic liberty. In my view, the evidence that the Constitution protects the rights of private property and contract is simply overwhelming. And in the short time I'm allotted tonight, I'm only going to be able to provide a brief survey of this evidence. But let's begin with the constitutional protection afforded to economic liberty at the national level, and I'm going to begin in particular with the Ninth Amendment that reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." There is a certain fittingness of me beginning this talk with the Ninth Amendment because 25 years ago, when I was a contracts professor, I was invited to speak at the 5th Annual National Student Symposium at Stanford Law School. It was a symposium on the First Amendment, and I gave a talk on a panel on freedom of association, of which I knew nothing about. And the punchline for my talk turned out to be the Ninth Amendment, which I also knew nothing about, except for the fact that when I was a student, I read the Ninth Amendment in Larry Tribe's constitutional law class, and I thought to myself, wow, this is fantastic. I love this amendment. And then I read that it doesn't mean anything and the courts will not enforce it. And that was the beginning of when I decided to not pursue constitutional law and become a contracts professor instead. But as a result of having been invited to speak at the Federalist Society and using the Ninth Amendment as my punchline, I decided, well, maybe I should learn something about it, and that is where I got into trouble. For 25 years, starting with the Ninth Amendment and venturing out to other provisions, I became a constitutional law person over my better judgment. But so it's fitting that where that talk ended with the Ninth Amendment, this talk begins with the Ninth Amendment. So let me say again what the Ninth Amendment reads. It says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." But what were these other rights retained by the people? Well, the evidence shows, I believe, that this was a reference to natural rights. Consider an amendment drafted by Roger Sherman, who served with James Madison on the House Select Committee to draft the Bill of Rights. Sherman's Second Amendment began as follows, quote, "The people have certain natural rights which are retained by them when they enter into society." Now, in this passage, Sherman uses all the terminology eventually employed in the Ninth Amendment: the people, rights, and retained, and the rights retained by the people are then expressly characterized as natural rights. But what then is meant by the term natural rights? The middle of Sherman's draft provides some examples. Quote, "Such are the rights of conscience in matters of religion, of acquiring property, and of pursuing happiness and safety, of speaking, writing, and publishing their sentiments with decency and freedom, of peaceably assembling to consult their common good, and of applying to government by petition for redress of grievances," unquote. Notice that the protection of property is at the heart of this list. Sherman's rendition of natural rights was entirely commonplace at the founding. Consider some examples. Here is the wording of another amendment that was proposed to the Constitution which did not get adopted, but this is what was proposed. Quote, "that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty and the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety," unquote. Similar provisions were proposed by state ratification conventions. Virginia offered, as its first proposed amendment, quote, "that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity, among which are the enjoyment of life and liberty, with the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety," unquote. Many state constitutions contain similar language as well. Massachusetts, "all men are born free and equal, and have certain natural, essential, and unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberty, that of acquiring, possessing, and protecting property, in fine, that of seeking and obtaining their safety and happiness." New Hampshire, "all men have certain natural, essential, and inherent rights, among which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and in a word, of seeking and obtaining happiness." Pennsylvania, "all men are born equally free and independent, and have certain natural, inherent, and inalienable rights, amongst which are the enjoying and defending of life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety." Vermont, "that all men are born equally free and independent, and have certain natural, inherent, and inalienable rights, amongst which are the enjoying and defending of life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety." So you get the message. All these provisions share in common the affirmation that the natural, inherent, and inalienable rights retained by the people include the rights to acquire, possess, and protect property, and the right to pursue happiness and safety. Now today, we would characterize the right to acquire, use, and possess property as economic, while characterizing the right to pursue happiness and safety as personal. But the provisions I just read show that the distinction between economic and personal liberty is anachronistic as applied to the founding, when these unenumerated natural rights were considered inextricably intertwined. Now, of course, like the rest of the Bill of Rights, the Ninth Amendment only restricted the power of the federal government. But what of the states? Well, let us now fast forward to after the Civil War, when the Republicans in Congress were struggling to protect the newly freed slaves in the South from the black codes that Southern states had adopted to reestablish white domination. In 1866, Congress enacted the first Civil Rights Act. This act mandated that all citizens of the United States, quote, "of every race and color, without regard to any previous condition of slavery or involuntary servitude, shall have the same right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens." So notice here how Congress identified the civil rights of all persons, whether white or black, as the rights to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property. In other words, at the very core of civil rights in 1866 were the economic rights of contract and property. Although, again, it's anachronistic to impose the distinction between economic and personal rights on that period. They made no such distinction. So now we must ask, well, just where in the Constitution did Congress find the power to enact the Civil Rights Act, protecting the economic rights of contract and property against infringement by the states? For many of you, the answer may be surprising. It is the 13th Amendment, the first section of which prohibits slavery or involuntary servitude except as punishment for crime, and the second section of which gives Congress the power to enforce this article by appropriate legislation. If the claim that the 13th Amendment empowered Congress to protect the economic rights of contract and property seems strained to you, it is only because we today failed to realize that slavery was, first and foremost, an economic system that was designed to deprive slaves of their economic liberty. The key to slavery was labor. The fundamental divide between the slave power and abolitionists concerned the ownership of this labor. Could a person be owned as property and be denied the right to refrain from laboring except on terms contractually agreed upon? Or did every person own him or herself with the inherent right to enter into contracts by which they could acquire property in return? Republican adherents of what was called free labor held the second of these views. Therefore, by abolishing slavery, Republicans in Congress maintained that the 13th Amendment also, ipso facto, empowered them to protect the economic liberties that slavery had for so long denied. In particular, to quote the bill, the right to make and enforce contracts, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of laws and proceedings for the security of person and property. This defense of the constitutionality of the Civil Rights Act under the 13th Amendment can be simplified as follows. The 13th Amendment prohibited slavery, and the opposite of slavery is liberty. Any unwarranted restrictions on liberty, whether personal or economic, are simply partial incidents of slavery. Therefore, Section 2 of the 13th Amendment empowered Congress to protect any citizen from unjust restrictions on liberty. Defending the Civil Rights Act in Congress, Michigan Senator Jacob Howard noted that a slave, quote, owned no property because the law prohibited him. He could not take real or personal estate, either by sale, by grant, or by descent or inheritance. He did not own the bread he earned and ate, unquote. He then observed, now, sir, it is not denied that the relation of servitude between the former Negro slave and his master was actually severed by this amendment, the 13th Amendment. But the absurd construction now enforced upon it leaves him without family, without property, without the implements of husbandry, and even without the right to acquire or use any instrumentalities of carrying on the industry of which he may be capable. In sum, by abolishing the economic system of slavery, the 13th Amendment empowered Congress to protect the economic system of free labor and the underlying rights of property and contract that define that system. To the dismay of congressional Republicans, President Andrew Johnson vetoed the Civil Rights Act. In his lengthy veto message, Johnson, a Tennessee Democrat, conceded that the civil rights identified in the act, quote, are by federal as well as state laws secured to all domiciled aliens and foreigners even before the completion of the process of naturalization. So he conceded that the rights that were in the Civil Rights Act were in fact the rights held by everyone. But he nevertheless protested that this claim of congressional power, quote, must sap and destroy our federative system of limited powers and break down the barriers which preserve the rights of the states, unquote. In response to Johnson's states' rights argument, supermajorities in both the House and the Senate overrode his veto. And they then set about to devise the 14th Amendment to constitutionalize the rights protected by the Civil Rights Act and more. The privileges or immunities of citizens of the United States protected by the 14th Amendment were not limited to the natural rights enumerated in the Civil Rights Act. They also included the privileges, the personal rights of American citizens enumerated in the original Bill of Rights. Further, the 14th Amendment did not adopt the Civil Rights Act's anti-discrimination language. Instead, the amendment protected the privileges or immunities of any citizen, whether white or black, male or female, from any abridgment whatsoever, not merely from discrimination. And because Democrats in the southern states, who had viciously attacked the Civil Rights Act and had all kinds of bad names for it, were eventually going to resume their seats in Congress, Republicans sought to place these guarantees beyond the power of any future Congress to repeal. But what the Republicans in Congress giveth, the Supreme Court taketh away. Just 5 years after its enactment, the court in the slaughterhouse cases, by a vote of 5-4, effectively gutted the Privileges or Immunities Clause by limiting its scope to purely national rights, such as the right of a citizen to be protected in his life, liberty, or property while traveling on the high seas. It also adopted Andrew Johnson's narrow reading of the 13th Amendment. Ever since, the economic liberties protected by the Constitution have been questioned by those who would put the economic powers of the slaveholder into the hands of Congress and state legislatures. Now, of course, these constitutionally protected economic liberties can still be reasonably regulated. After all, even the First Amendment's right of freedom of speech and assembly are subject to reasonable time, place, and manner regulations. As Justice Bradley explained in his dissenting opinion in Slaughterhouse, quote, "The right of a state to regulate the conduct of its citizen is undoubtedly very broad and a very broad and extensive one, and not to be lightly restricted. But there are certain fundamental rights which this right of regulation cannot infringe. It may prescribe the manner of their exercise, but it cannot subvert the rights themselves." By eliminating the Privileges or Immunities Clause while distorting the meaning of the Due Process and Equal Protection Clauses, along with ignoring the original meaning of the Ninth Amendment, the Supreme Court has deprived Americans of these express protections of all their natural rights, including the rights to make and enforce contracts and to inherit, purchase, lease, sell, hold, and convey real and personal property. But thanks to the foresight of men like Virginia's James Madison, who conceived the Ninth Amendment, and Ohio's John Bingham, who drafted the Privileges or Immunities Clause, Due Process Clause, and the Equal Protection Clause, these protections of our natural rights, both personal and economic, remain a part of the written Constitution of the United States. They can be denied, they can be disparaged, and they can be abridged, but they have not yet been repealed. Thank you.
Ladies and gentlemen, it is such a pleasure to be here at the Federalist Society. Your ecumenicalism and your openness to competing ideas is always a pleasure. I always learn from these debates, and I'm so delighted to be here. It's also a pleasure to debate my friend and colleague, Randy Barnett. Randy Barnett is the leading intellectual inspiration for a libertarian legal movement that is sweeping the country. It is transforming our legal discourse, and he deserves great respect for his influence. But ladies and gentlemen, I am here this evening to persuade you to resist Professor Barnett's siren call. It is a special pleasure to stand here to defend the traditional conservative view that judges should not second-guess political debates in the name of amorphous rights that don't appear in the text or history of the Constitution. Indeed, that promise was precisely what attracted me to the Federalist Society in law school when I, as a bipartisan renegade, would sneak into Federalist Society meetings trying to evade the glances of my professors and would receive with relish the Federalist claim that liberals were short-circuiting all of our most important political debates by making up rights that don't appear in the text of the Constitution, like the right to privacy in Roe, and as a result were not interpreting a law but making it. It was a surprise to find that in recent years, the libertarian movement has called into question that consensus. It's argued that Lochner was rightly decided, and that indeed a great number of laws and regulations should be struck down in the name of unenumerated rights with the most tenuous roots in the text or history of the Constitution. My job today is to persuade you to resist economic judicial activism. So as I think about the challenge that we've been set to talk about this evening, it strikes me that there have actually been three separate strains of legal conservatism over the past 30 years or so, and that only one of them was the one that I was drawn to in law school, namely the traditional view of conservative judicial restraint. The clash between that view and the more libertarian view appeared at a debate that Justice Scalia, who was then on the U.S. Court of Appeals for the D.C. Circuit, had with Richard Epstein at the Cato Institute in 1984. And Scalia, standing before a standing room only crowd, defended the view that judges should restrain themselves from overturning laws in the name of rights or liberties not clearly and expressly enumerated in the Constitution. Every era raises its own peculiar threat to constitutional democracy, he said. The reversal of a half-century of judicial restraint in the economic realm comes within this category. Scalia, as a Federalist, had his own qualms about the unconstitutionality of unlimited federal power, but he was not in favor of striking down laws in the name of ambiguous and contestable economic rights. And Scalia argued that conservatives who'd criticized earlier courts, like the Warren Court, for liberal judicial activism, now faced a moment of truth they had to show the courage to reject conservative judicial activism in the economic arena as well. And when Professor Epstein heard what Scalia had to say, he threw away his prepared remarks. His head almost exploded. And he delivered, as you know, only Richard Epstein can, a spontaneous attack. He said, freely admitting he was questioning the conservative conventional wisdom, he said judges should be much more aggressive in protecting economic liberty. There are many blatantly inappropriate statutes that call out for a quick and easy kill, he said, citing minimum wage laws and other legislative regulation of the economy. He excoriated the Supreme Court for refusing to strike those laws down and said, one only has to read the opinions of the court on economic liberties and property rights to realize these opinions are intellectually incoherent. Some movement in the direction of judicial activism is clearly indicated. So that debate in 1984 established a clear distinction between traditional conservatives like Scalia, who generally support broad national power and are suspicious of economic judicial activism, prefer to enforce textually enumerated rights and not to go beyond the text, and libertarians like Epstein and Professor Barnett, who support aggressive enforcement of unenumerated rights of contract, of autonomy. They both support striking down the healthcare reform and also favor gay marriage. They are good libertarians politically, and they would enact their political preferences judicially with arguments that are hard to locate in constitutional history. Their avatar on the Supreme Court is not Scalia, but Justice Kennedy, who is most sympathetic to their views. And since that time in 1984, a third strain of conservative legal intellectualism has developed, and I would call that Tea Party conservatism. Tea Party conservatives share with the libertarians a suspicion of broad federal power. They want to use the courts to strike down a great deal of the post-New Deal regulatory state as well as the healthcare law, but of course they part with the libertarian conservatives on social issues and, unlike the libertarians, oppose abortion rights and gay marriage rather than supporting it. And on the Supreme Court, I would say the avatar of Tea Party conservatism, as I've described it, would be Justice Thomas, who is quite principled in his devotion both to social conservatism and to anti-federalism. What I want to try to persuade you of is that if you want to remain true to the Federalist Society tradition of judicial restraint, you will reject the libertarian anti-federalism of both the Barnett wing and the Tea Party wing of the conservative legal movement. Think about the range of federal statutes that would have to be struck down if this vision were taken seriously. In 2005, I wrote an article for the New York Times Magazine that talked about the resurgence of a libertarian movement that some associated with the phrase "the Constitution in exile," a phrase that Judge Douglas Ginsburg had used to identify legal doctrines that established firm limitations on state and federal power. And the movement, critics claimed, had no shortage of targets. Cass Sunstein, who also wrote about this libertarian movement, predicted that as the movement succeeded, many decisions of the Federal Communications Commission, the Environmental Protection Agency, Occupational Safety and Health Administration, and possibly the National Labor Relations Board would be unconstitutional. The Social Security Act would be under constitutional stress. The Security and Exchange Commission, maybe even the Federal Reserve would be in trouble. Some applications of the Endangered Species Act and the Clean Water Act could be struck down, and in what Sunstein described as an extreme nightmare scenario, the right of individuals to freedom of contract would be so vigorously interpreted that minimum wage and maximum hour laws would also be jeopardized. Now, when I see a little applause in the front row. Constrain yourself, madam. I know it's victory is sweet. When Sunstein and I talked about this possibility of a libertarian movement, we were dismissed as scaremongering. Surely conservatives wouldn't truly press all of these points. But lo and behold, the Federalist Society has now convened an entire conference on the question of whether Lochner was right and whether maximum wage and minimum hour laws should indeed be struck down. And indeed, in the Tea Party movement, all of the scenarios that Sunstein identified are explicitly embraced. Tea Party conservatives question the constitutionality of the Federal Communications Commission, the Environmental Protection Agency, the Federal Reserve. In the 5,000-year leap, Cleon Skousen's Bible of Tea Party constitutionalism, endorsed by Glenn Beck, there appear 101 constitutional questions for federal candidates, which indeed embrace precisely the economic results that I have suggested. And in the judiciary, we have judges questioning the Endangered Species Act and health and safety regulations along the same lines. So there's nothing unprincipled about this position. It is indeed carrying to logical conclusions the principles that Professor Barnett, Professor Epstein, and others embrace. But the scope of judicial invalidation, the aggressiveness of the use of the courts to short-circuit contested economic debates can no longer be doubted. All right, what is wrong with this scenario? You applaud it. Sure, many of you I know don't like the Fed and think it would be great to strike down the Endangered Species Act. But what about your constitutional principles, your pledge to each other that you would only use the courts to strike down laws on the basis of rights that were clearly rooted in the text and history of the Constitution? And this requires us to think about Lochner. What was the problem of Lochnerism? Why is it that conservatives like Justice Scalia traditionally viewed it as illicit and impermissible? There are several ways of stating the problem of Lochnerism, and they're found in different forms in the two dissents by Justice Holmes and Justice Harlan. For Holmes, the problem of Lochnerism was a problem of text. The Constitution doesn't speak of freedom of contract, as the court later echoed in West Coast Hotel and Parrish, and judges should not strike down laws on the basis of unenumerated rights because they're most democratically vulnerable. They're most in danger of imposing their own political preferences on the country when they enforce amorphous ideas of reasonableness without a textual peg. And the Federalist Society has argued powerfully that textualism is important. Your criticisms of Roe, for example, your opposition to a judicially invented right of gay marriage will be on far weaker grounds if you embrace unenumerated activism in the economic arena. But the problem of Lochner is not only a problem of text, it's also a problem of deference in the face of uncertainty and contestability. This was Justice Harlan's point in his less rhetorically memorable, but in some ways far more legally plausible dissent. Harlan said reasonable people can disagree about whether or not maximum hour laws are necessary to protect bakers' healths. Judges should defer to legislatures in the face of uncertainty. Professor Barnett's policy arguments against minimum wage laws in Lochner and elsewhere are plausible. I know many of you have doubts about them on policy grounds. My law school classmate and friend David Bernstein has just written a wonderful book, Resurrecting Lochner, trying to argue that the minimum wage laws there were ways of favoring unionized workers over their ununionized competitors. That's a good policy argument. But the point was that majorities of citizens in legislatures across the land during the Progressive Era disagreed with that economic analysis, and judges have no special competence to enforce economic rights in the face of widespread disagreement. Professor Barnett gave a learned disquisition on the intention of the framers of the 14th Amendment about economic rights. But the truth is that the history is far more complicated than he suggests. It's true that the framers of the 14th Amendment had a suspicion of class legislation, namely legislation that took property away from A and gave it to B, and they thought that you could only pass economic regulations that served the public interest. Now, there are two problems with translating or applying this class legislation prohibition in the 21st century. The first is that for the framers, this prohibition on class legislation only applied not to all state action, but to a very small category of rights. They called them civil rights or privileges or immunities. These rights were uniform from state to state. They were available not as a matter of discretion, but of right. But they did not cover most of the business that the government did. They didn't cover welfare state activities because, of course, there was no welfare state. And beyond that narrow scope of civil rights, the government was free to discriminate against people or in favor of them on the basis of race, or on the basis of economic favoritism, or on any basis as it pleased. How to translate this idea of limited absolute equality into a world where the government monopolizes highway contracts and health care and the provision of health and safety laws is something the framers could not have answered because they had no welfare state. And to suggest, as Barnett would, that the framers' narrow notion of class legislation in the libertarian marketplace should be expanded across the entire scope of what the federal government does is a historical leap of imagination. It's not justified by what the framers anticipated. Also, another historical atavism of Barnett's argument is that for the framers, economic rights were to be enforced by Congress, not the courts. As Professor McConnell has argued repeatedly, the whole point of the 14th Amendment, the most important section was Section 5, which was to authorize Congress to pass the Civil Rights Act. The framers would have been surprised and appalled by the notion that courts had primary responsibility for enforcing these economic rights in the face of contrary judgments from Congress. And of course, the third problem with translating the Lochnerian prohibition on class legislation into the post-New Deal world is that the very notion of what sort of regulation is in the public interest, which was once contested, became uncontested. That was the problem with Lochner. People agreed, at least judges thought they could agree in 1905 about what regulations were affected by the public interest, which industries were quasi-monopolies. They were applying their formalistic categories. But when the economic reality of the Depression dislodged the idea that intervention on behalf of one group of workers would harm society, and when indeed intervention on behalf of some came to be seen as necessary to avoid a burden on all as the welfare state got up and running, it no longer was possible for judges confidently to enforce these 19th century categories, which incidentally were not. This has nothing to do with the framers' intentions. These were common law categories dating back to Thomas Cooley that were the stuff of lawyers' work, but to ascribe them to the framers is not persuasive, and indeed, once consensus about what was in the public interest and what wasn't disappeared, judges appeared to be political when they were enforcing these contested categories. And that's why Justice Jackson, during the New Deal, a judicial conservative, a pillar of judicial restraint, argued that the court should get out of the business of enforcing, second-guessing Congress's economic judgment. He tried to write an opinion enforcing the old categories, but found that it wouldn't write, that essentially what he was doing was making economic judgments about what was reasonable, as Professor Barnett argues, that he had no special competency to make, and for that reason, he said that judges should get out of the business entirely. Now, is it possible that the court went too far in advocating judicial abstinence in economic cases? Perhaps. Whenever I teach Williamson and Lee Optical, I agree that the court was making up fake reasons for upholding this requirement that you had to go to an optometrist rather than optician to get a new prescription. Obviously, the real reason was just to favor the optometrists who felt threatened by LensCrafters, a new group of economic competitors. The court made up a fake reason that maybe people's eyes would be infected and they needed to get eye exams from a professional. So I can imagine in a few cases like that where you really have a naked bit of rent-seeking, a clear giveaway to one group of economic competitors over another, perhaps enforcing economic liberties might be appropriate. Total deference might have gone too far, but a strong presumption of deference, rather than what Barnett advocates in his book, a presumption of liberty, is the only thing that can prevent judges once again from entangling themselves in this contested economic arena. I want to also persuade you that the cost of embracing Barnett's vision of economic judicial activism is also to require you to embrace judicial activism in areas like personal autonomy, sexual autonomy, from abortion to gay marriage. So think about the justice on the Supreme Court who's most likely to buy the healthcare challenges. Who would it be? I'm a law professor, I can call on people, I can't see you, so just call it out. Who is most likely to buy the healthcare challenge? Thomas seems absolutely most likely in the name of a narrow version of the Commerce Clause that says that you can only regulate exchange but not manufacture. And I think the justice, the second most likely to strike it down, though, might well be Kennedy. He would strike it down not on the basis of the Commerce Clause, but on the basis of an unenumerated right not to be forced to buy what you don't want to buy. And this, as Charles Fried said in his riveting Senate testimony last week, is really Lochner resurrected. The claim that you can't be forced to buy health insurance, or broccoli, or asparagus, or gym memberships, as the governor of Virginia has so memorably argued, isn't an argument about the Commerce Clause. It's an argument that there's a free-floating right of personal autonomy that can't be infringed and that should prevent the government from forcing you to buy what you don't want. But that same right, I want to argue, is a right that Justice Kennedy might also embrace next year in recognizing a right to gay marriage. If liberty presumes an autonomy of self, as Kennedy said in the sodomy case in Lawrence in Texas, that autonomy of self might both prevent you from buying gym memberships you don't like and also guarantee your right to marry people that you love regardless of their gender. And it would be hard for you to distinguish on the basis of text or history and to say that that free-floating autonomy right, which Justice Scalia, of course, called the sweet mystery right, at the heart of liberty is the right to define one's own conception of meaning, of the universe, of the mystery of human life. It would be hard to say that should apply in the healthcare arena, but not in the gay marriage arena. Will there be 5 votes on behalf of striking down healthcare in the name of a Lochnerian right of personal autonomy? Predictions are dangerous, but we're among friends. I tend to doubt it. I think there's a strong argument that Justices Roberts and Alito are deferential to Congress. They are suspicious of creating unenumerated rights without clear textual limit, and they're respectful of precedent. I just this afternoon went to the wonderful Supreme Court database and tried to see which justices were most likely to strike down federal laws on the Roberts Court. So between 2006 and 2009, there were 6 federal laws struck down. The justice most likely to strike down those laws was Justice Kennedy, who voted with a majority in 5 of the cases. Roberts was next with 4, Thomas and Scalia 3, Alito only 2. Alito almost never votes against the federal government in criminal or in statutory cases, and the idea that he would lightly strike down an act of Congress on the basis of elusive unenumerated rights strikes me as not necessarily convincing. Regardless of what the court does with health care, I want to close by begging you, ladies and gentlemen, to think hard before resisting the seductive calls of Barnett. I know that many of you do have policy preferences that coincide with his. As it happens, I do too. I have strong libertarian preferences. But I was taught by the Federalist Society and by my great law school professors that the highest achievement in constitutional interpretation is to separate your policy preferences from your legal conclusions, to be scrupulous about only second-guessing democratic decisions when those arguments could be clearly rooted in text and history, and people on both sides of the political spectrum could embrace them. Many of us have judicial heroes. There are plenty of conservative judicial heroes of this vision of traditional anti-Lochnerian judicial restraint. My own hero, who I'd like to publicly acknowledge in this setting, is the great Judge Wilkinson, who will be moderating the panel after this one. Judge Wilkinson has been a model in resisting arguments based on shadowy textual arguments. He has criticized the Heller gun decision. He criticizes Roe v. Wade. He was in dissent in cases attempting to strike down the Endangered Species Act. He is a judge whose policy preferences often do diverge from his conclusions because he recognizes that at stake is not only economic liberty, which is what Professor Barnett wants to persuade you to embrace, but also democratic liberty. The liberty of democratic majorities to debate hotly contested policy issues, to reach contrary conclusions, to settle their disputes politically rather than judicially in areas from abortion to gay marriage to economic liberties is something that Judge Wilkinson recognizes. So I commend his restraint to you, and I look forward to welcoming you back, those of you who are thinking of straying into the traditional fold of conservative judicial restraint. Thank you so much.
Should this crowd resist the siren song you're offering, I will...
Resist my seduction.
It's hard, Randy, I know.
I did notice that...
I didn't come here to talk about gay marriage, Jeff.
Don't ask, don't tell.
Attractive though I find you.
Yes. You're a beautiful man as well.
Don't you just love when progressives tell conservatives how to be conservatives? I love it. It's a standard move that's made. Jeff comes before you and tells you what what being a conservative means. But I was thinking about how much of his speech would work in front of the American Constitution Society. How many are those arguments would he ever make in front of the American Constitutional Society to persuade them to accept whatever conclusion that he wanted about and none of them would work. Virtually none of them would work. they would say, well, what's wrong with that? Well, what's wrong with that? Well, what's wrong with that? But only you're the ones that he can play this judicial restraint card against. He thinks he can anyway, but he's wrong. He cannot. He can't fool conservatives. He can't pull the wool over your eyes. Judicial restraint is an admirable quality. It means that judges should follow the law. But included in the law is, unfortunately for progressives, the Constitution of the United States. And the whole Constitution of the United States, even the parts that have been redacted. And that's the problem. That's, by the way, the lost Constitution that I talk about in my book. The constitutional exile movement trope that Jeff wrote a New York Times magazine article about was supposed to be about opining for constitutional law that preceded the New Deal. But very few of us opined for that law. That law had some good things about it. It had some really awful things about it. And there's been many improvements to the constitutional law since 1937 that no one wants to go back on. But the lost Constitution that I've written about and that others have talked about is really those parts of the Constitution that have been redacted by the Supreme Court. And first among them are the Ninth Amendment to the Constitution, which Jeff didn't mention, and the Privileges or Immunities Clause of the 14th Amendment, which Jeff didn't mention. So the question is, do those clauses have any meaning, and what that meaning is? And in my opening remarks, I tried to explain in a shorthand way what I thought the meaning of both those clauses are, and it is not judicial restraint. It is not anything appropriate to judges to ignore the meaning of the text of the Constitution. Why? Why? Because what would be the reason? Because you don't want judges interfering in the democratic process? But that's what the Constitution is there for. It's there to restrict the democratic process. The democratic process gets its legitimacy from the restrictions that are placed upon it. Otherwise, it would be unbridled majoritarian rule, and that would not be legitimate. What makes majoritarian rule legitimate is that it's constrained by the protection of the rights of the minority and really by everybody, not just the minority, by everybody's individual rights. That's what makes democratic majoritarianism legitimate. And in our system of government, it's judges who are charged with the responsibility of enforcing and protecting the Constitution. Jeff tells us that the framers of the 14th Amendment would have been appalled to hear that the courts would enforce the 14th Amendment. Well, to the contrary. It is true, they did add Section 5 of the 14th Amendment to empower Congress to enforce its provisions, because prior to that, it had been doubted that Congress had the power to enforce the Privileges and Immunities Clause of Article 4, so they needed an express delegated power in order to do that. But the whole point of Section 1 was to empower the courts because, remember, the Democrats were coming back. And the Democrats hated the Civil Rights Act, and the idea was to enshrine the rights and privileges that were in the Civil Rights Act into the Constitution so that a future Congress could not undo those rights. And who else was going to stop them but the courts? Did, by the way, the founders or the authors of the 14th Amendment put great stock or have great confidence in the ability or steadfastness of courts to enforce these rights? They did not. In fact, they thought that courts would not be strong enough to withstand democratic majoritarianism in the protection of individual liberty, but they couldn't really see an alternative to relying on courts to do whatever they would do, and they were right. Courts haven't been steadfast. That's the reason why we have lost parts of the Constitution. So let me just take, to wrap this up, by talking about the case that Jeff chose to talk about, and I think it's a very good case to talk about, the Williamson v. Lee Optical case. How many of you have read Williamson v. Optical so far in constitutional law? Okay. How many of you, in reading it, read the lower court opinion in that case? Not normally assigned. It's in my casebook, though, but I'm sure that those of you who didn't raise your hand didn't have my casebook, or did raise your hand. So here's the thing about Williamson v. Lee Optical. Jeff is right. It was an example of naked rent-seeking to assist ophthalmologists and optometrists. It was a regime of restrictions on opticians and what opticians could offer in the marketplace. And it basically essentially denied the ability to have what essentially lens crafters now provides you, which is the ability to go into a place, have your lenses replaced, have an eye exam on the premises. It prohibited all that as being against public policy. The very thing that everybody takes for granted was prohibited by Oklahoma. And it was a way of steering business to ophthalmologists and optometrists. But the question is, how are the courts going to detect? How would a court ever detect this rent-seeking that was going on? How would they know that the legislative process had been hijacked by a special interest group? Well, the lower court actually, if you read that opinion, it's a very interesting opinion. First of all, it applies a presumption of constitutionality. It does not apply a presumption of liberty. But then it goes on and says, look, what we need to know is what is the health and safety rationales for the various restrictions that are being put on these people who are pursuing a lawful occupation, an economic liberty of pursuing a lawful occupation of being an optician. And they went through each one of them, and they really couldn't find a legitimate health and safety rationale for any of them. For one thing, I'll just give one little example from the case, and that is, because I love the name, lensometer. There was a lensometer. When you went into a optician and they wanted to replace your lenses, they would put your frames in a lensometer, and that would read off the prescription. Then they could make you another set of lenses that fit into another set of frames. And so they basically, the law barred opticians from using the lensometer to do this. But one of the things the court pointed out was that if you went to an ophthalmologist or an optometrist, they would put your lenses into a lensometer, and that would be run, that lensometer would not be run by a doctor, but would just be run by a clerk, be run by a technician, something that the opticians could do. So they couldn't find any rational basis for restricting the ability of opticians to do this kind of work. As a result, they struck the law down as being unconstitutional. They discovered the rent-seeking not by looking for rent-seeking. They discovered the rent-seeking by asking what really is the health and safety rationale for this bill. And that's what I would suggest that the protection of economic liberty would consist of. It would be consisting of asking the government to come up and explain what really is what is the rationale, what is the health and safety rationale for regulating this economic liberty. Presumably, if there is one, they can articulate it. But if they can't articulate it, or what they do articulate really makes no sense, then you can start to presume that what the court in Lochner said might be going on. It might be other motives. Other motives might be responsible for this legislation, and then it properly should be struck down. Because at this point, we would not be having the reasonable regulation of liberty, which is permissible under the 14th Amendment and under the 9th Amendment, but we would be having the arbitrary and irrational and unjust restriction of liberty, which is prohibited. That is what it means to destroy a right or to subvert a right, rather than to reasonably regulate the exercise of that right.
Would I make these arguments to the American Constitution Society? For better or for worse, I've been making them for 2 decades. And before recently, these arguments fell on deaf ears. So I write for the New Republic magazine, which has long embraced this tradition of liberal judicial restraint. The legal editors of the New Republic included Learned Hand and Felix Frankfurter, who during the Progressive Era insisted progressivism is founded on a suspicion of courts. They argued for a limited judicial role. I and lots of people before me of doing the same thing, for example, criticizing Roe v. Wade, even though we're pro-choice. So we've been taking a pretty consistent line in favor of limited judicial power for a long time. Now, for many years, liberals were not interested in these arguments, and they embraced the kind of expansive Warren Court liberal judicial activism that the Federalist Society was founded to denounce. But what's striking recently, in the past 5 years or so, is that when I think of the strains of liberal legalism, many of them are converging against Warren Court activism and in favor of a limited role for courts. So you have people like minimalists, like Cass Sunstein, who argued that the court should move one step at a time and rule narrowly rather than broadly whenever possible. Chief Justice Roberts struck a similarly minimalist role in his confirmation hearings. You have democratic constitutionalists, like Robert Post, who say the courts can sometimes nudge society a little bit, put the brakes on in some cases, but can never leap out too far ahead, that basically political change should come from the political process rather than the courts. And even President Obama, in his book, The Audacity of Hope, has a chapter on the Constitution. He criticizes liberals for relying too much on the courts to fight their battles for them in the Warren era, and says that they should realize that the great advances for civil rights and liberty have come from politics rather than judges. So that's why I do think, ladies and gentlemen, you're at a moment of truth. I mean this sincerely and honestly. There are strains among Federalists who continue to embrace the traditional Justice Scalia, Judge Wilkinson position that is resisting an expansive, aggressive role for courts, who are appalled that conservatives are running to courts to reverse their legislative defeats in areas from campaign finance to healthcare to financial regulation to economic regulation. But there are other strains, the libertarians and the Tea Party people, who are arguing for a much broader role of courts, and you have to choose. Now, Professor Barnett's response substantively is, I'm ignoring the Privileges or Immunities Clause in the Ninth Amendment. Randy, I'm not. What I said is that the Privileges or Immunities Clause, as originally understood, did indeed suggest that there were certain unenumerated rights in the Civil Rights Act of 1866, namely the right to make and enforce contract, to sue and be sued, and so forth. But the framers of the 14th Amendment anticipated that that right would be applied in a very narrow category of cases, not across the entire range of state action, but only in cases affecting what they considered fundamental rights that were uniform from state to state, and that you could have regulations that were necessary for the public interest. And what I said, and what you didn't engage, is that although there was once some consensus that only health and safety regulations were in the public interest, that consensus became contested and was abandoned during the Progressive and New Deal era, when welfare and economic disadvantage on behalf of some came to be seen as a burden on all of society, because if you didn't compensate vulnerable workers, then the rest of society would have to pay. There is nothing in the text or history of the 14th Amendment that can answer the question of whose conception of what regulations are affected by the public interest is permissible. The point is that the category had become contested, and for you woodenly to incant a pre-Lochnerian understanding of public interest jurisprudence, again, has nothing to do with the conception of the framers, but instead is based on amorphous common law doctrines that are no longer accepted by most of society. But you don't rest your argument on originalism. I'm struck that in your arguments about the unconstitutionality of health care, you say this is not an argument about originalism, it's about structural limitations on Congress. Those are defined at a much higher level of abstraction than what the framers of the Constitution took for granted. It's for that reason that Professor Charles Freed, a great friend of the Federalist Society and embodiment of the Scalia-Wilkinson camp of judicial restraint, thinks that what you're really arguing for is free-floating autonomy rights that have very little direct warrant in the text and history of the Constitution, but have to do more with libertarian philosophy than with text or original understanding. So all of the methodologies that you, Federalists, have embraced over the past 30 years, deference to text, original understanding, precedent, not to mention pragmatic considerations and democratic liberty, all counsel against the resurrection of Lochnerism. And for that reason, I hope very sincerely that you will continue to resist it.
Let me ask the people who wish to ask a question. Now is the time. We have a limited time period for questions. But let me pose one while people are coming up to the microphones.
You should go to the microphones, right?
Yes. Professor Barnett, while this person is coming up to the microphone, I did want to ask you about the presumption of liberty. And where do you find that in an originalism approach to constitutional interpretation?
Well, the presumption of liberty is not a product of originalism. Neither is the presumption of constitutionality. Neither the presumption of constitutionality, which is the established doctrine, nor the presumption of liberty are in the Constitution itself. Both are what we call constitutional constructions. Last year at this time at the University of Pennsylvania, my talk was on the difference between interpretation and construction. And interpretation has to do with what the meaning of the text is, and that an originalist believes should be interpreted according to its original public meaning. But once you've interpreted the text according to its original public meaning, then you have to put it into effect. And the information contained in that text might not be sufficient to decide all cases and controversies. The activity of applying original public meaning to particular cases and controversies is the activity of construction. And then you have to come up with rules and doctrines, which is what the substance of constitutional law is, in order to put that into effect. The prevailing constitutional construction is that of the presumption of constitutionality, and that's nowhere in the Constitution either. So the question is the presumption of liberty more consistent with and more fitting to what is in the Constitution, for example, the Privileges or Immunities Clause or the Ninth Amendment, or is the presumption of constitutionality more fitting? And so I would just say both have the same status with respect to originalism. You just have to compare that with what the Constitution does say to see which is the best set of rules in order to put into effect what the Constitution says.
Your Honor and professors, it's a pleasure to be here. Thank you. Professor Rosen, I'd like to attack a premise of yours and also ask a question. You talked about how the reasoning of personal autonomy might be used to strike down health care, that can't force me to buy health care. At the same time, allow people the right for gay marriage or to redefine marriage. My question basically is, to me, how is homosexual marriage or gay marriage it's a social contract, and in effect what it's doing is forcing society to recognize that in ways that, such as like if I was an employer and was to offer a job, or something, how, to me, they're the same thing. It was forcing people to accept and buy health care is the same thing as forcing people to accept a definition of marriage, which they wouldn't want to normally accept, perhaps. So to me, they're the exact same thing. How, if it was just symbolic, then why would they need this legal right to force others to adhere to that? So I guess that's my question.
An excellent question. And again, I should say, although personally pro-gay marriage, I have questions about health care. I do not believe that the court should either recognize a right to gay marriage nor strike down health care. And the answer, from the presumption of liberty, from the libertarian constitutionalism, is that it's the perspective of the individual, not of social acceptance, that is the test of an autonomy right. And just as individuals should have the total right to make contracts or not, to buy anything they want or not to buy anything they want, so individuals should have the right to make marriage contracts, to marry whomever they want, not only people of the same gender, but also, as Justice Scalia suggests, an extreme interpretation of the libertarian autonomy principle would favor polygamy as well. So social acceptance is not the baseline. As Mill reminds us, it's as long as my conduct does not harm others, the disapproval of others is of no relevance in defining the right. If liberty presumes an autonomy of self, that extremely abstract right should create great ability of individuals to resist state coercion in any form. And I should say it should sweep even more broadly than this when I think of future privacy cases like the possibility of broad surveillance cameras that Judge Livingston and I have both written about. Imagine that the government were to unite all of the public and private surveillance cameras that are now disaggregated and put them live on Facebook. And imagine it were possible to trace someone from door to door if these images were stored and basically track their movements 24/7. I could well imagine Justice Kennedy striking that down also. In the name of an autonomy of self, the government is not allowed to track my movements, which inhibits them and therefore coerces me into a predetermined method of life. I cite that as an example to show how extraordinarily abstract and free-floating and untethered to text and history this autonomy right is, and that's why you can call it construction all you like, but it is vulnerable to precisely the vices that conservatives criticized liberals for when they invented the original Roe right, namely the connection to the paradigm cases that animated the framers of the 14th Amendment is very hard to discern.
Harvard Law School. Professor Rosen, you mentioned several times that you would ask the federal side to recognize, and your views are that judges should really only get involved in enforcing clear enumerated rights. And one of the arguments that you made is that in the economic realm, people are going to disagree. Reasonable people can disagree about, what kind of rights should be protected, what proper public purposes are. It seems to me that that's true of almost every area of constitutional law. Reasonable people disagree about what freedom of speech means, what the Fourth Amendment's protections mean, what due process means, what equal protection means, just about anything that judges get involved with. In fact, if the whole point of judicial review presumes that judges will disagree with presumably reasonable legislators. So is your argument specific in any way to economic liberty, or is this really just a general argument that we should be much more skeptical of judicial review entirely?
An excellent question, and the short answer is that I am generally skeptical of judicial review and have defended a version of judicial abstinence in the Frankfurter, Holmes, Hand, Wilkinson tradition that is skeptical of expansive privacy, Roe v. Wade-like decisions, as well as economic decisions. So a humility and a desire to defer in the face of uncertainty is not limited to the economic realm. On the other hand, as Justice Brandeis, a great advocate of judicial deference, recognized, the courts are most legitimate, they're on the most solid grounds when they at least have a textual peg. So Brandeis is someone who defers to state experimentation, generally upholds economic regulations, but occasionally will intervene both in the economic arena, where he struck down the National Industrial Relations Act, part of the New Deal, even though he dissented from other New Deal decisions because he thought that was such a violation of separation of powers. And in the Fourth Amendment and First Amendment area, he's the greatest prophet of translating free speech and Fourth Amendment privacy in light of new technologies. He comes up with the most important defense of free speech ever written, better than Holmes in the Whitney case. And in the Fourth Amendment, he insists that wiretapping has to be held to violate the Fourth Amendment, or else we would have less protection in the age of the wires than the framers had when trespass laws protected their privacy. So that's to say that the follow-up is, I don't believe the judges should abdicate entirely. They should just test themselves. They should hesitate to strike down laws. But when they have clearly enumerated textual rights, like the First Amendment, like the Fourth Amendment, then they're on more solid grounds, and there some degree of judicial translation can be defensible.
I just don't think that works, Jeff, because there's clear textual basis for unenumerated rights in the Ninth Amendment. There's a clear textual basis for unenumerated rights in the Privileges or Immunities Clause. It's as clear and as textual as the Due Process Clause, the Equal Protection Clause, and the First Amendment. And somehow we are oftentimes taught that the First Amendment, for example, is one of those express prohibitions. Caroline Products, footnote 4, says that it can be protected because it's an express prohibition. But you know as well as I do that the minute, just like 2 minutes after you start protecting the freedom of speech, you're off into the land of constitutional construction, which I believe is appropriate and inevitable, in order to figure out what the heck that means. Of course, you begin with a clear textual injunction, protect the freedom of speech. Every bit as clear as privileges or immunities of citizens of the United States. But then, in order to apply that clear textual provision, you are automatically in the realm of time, place, and manner regulations, and you have to teach a whole semester just to get all the doctrine out that regulates the protection of freedom of speech. And you don't want to stop enforcing those parts of the Constitution. I really think this question really does make you have to go one way or the other. Either you ignore the Constitution and just let it up to the legislature, who is supposed to, by the way, to be bound by the Constitution, or you have to do the best you can to try to put what the Constitution does say into effect, as you favor doing.
If I could just briefly, Brandeis resisted that Manichaean dichotomy, and I want to say again, I'm not saying unenumerated rights should never be enforced. You and I have long studied and debated the history of the Privileges or Immunities Clause. I understand that the framers of the 14th Amendment thought the right to make contracts was an unenumerated right, but they may have believed, and the evidence is unclear, that those unenumerated rights, like contract, get a different standard of scrutiny than the textually enumerated rights. So there's evidence in the Slaughterhouse dissents that textually enumerated rights might get fundamental rights status and strict scrutiny, whereas unenumerated rights, like contract, might get something close to rational basis review or equality treatment. That answer cannot, the history is not clear, but this was a plausible disagreement among the framers, and for you to say that because construction is always necessary, judges are often running and completely empowered just to create abstract rights with very little connection to the original cases that gave them birth, again, is inconsistent with original understanding. I want to make again the originalist argument. Can you identify a single moment, either during the history of the framing or the history of the 14th Amendment, that the framers and ratifiers embraced an aggressive vision for judges? When did they ever say that they thought judges would be the primary defenders of these rights, unenumerated or enumerated? There's no evidence in either of those framing periods for that kind of judicial activism.
The 14th Amendment did not enact Mr. Felix Frankfurter's jurisprudence.
But it arguably did enact that of Justice Brandeis.
It did?
We have time.
Yes, it did.
Order in the court.
Yes.
So we'll have time for one more question. We could go on, as you can see, for 2 hours. We have another panel behind us.
From William Mitchell College of Law. I really enjoyed the discussion we've had here with both of you, and I have an interesting question, I think, for each of the panelists here, is that, well, we've talked a lot about the 9th and the 14th Amendment and the structure of constitutional interpretation there, and as is common, I guess, with most realms of constitutional law, we tend to ignore Article 1, Section 10, Clause 1, being the contract clause, and whether or not that should or does play a role in this kind of economic liberties discussion here.
Well, of course it does, and it should. It is an express prohibition on how states are, on the power that states have not to abrogate contracts. And so if I had more time, I would definitely have mentioned the Contracts Clause as an express prohibition. But I think one of the things I will just take your question as an opportunity to do, and I appreciate it, is to return us to discussion of economic liberty, which is the topic of this debate. And all I would just urge is, given the existence of the Contracts Clause, as well as these other provisions of the Constitution, that there has been no reason to believe that economic liberty is any less deserving of protection than personal liberties are. It's the dichotomy, the Caroline Products footnote 4 dichotomy between personal liberties and economic liberties that needs to be justified. And so whatever your view of judicial restraint might be, you need to apply it consistently to both, because there is no reason to think that the Constitution is any more favorably inclined towards personal liberties under the 14th Amendment than it is towards economic liberties. And the Contracts Clause is good reason to expect that if the founders were forced to choose, which they weren't, I mean, I think that they might opt for the economic liberty side of the equation, but I don't think we need to make that choice because the Constitution protects both.
I think it's a great question, and I would say, of course, the court should enforce the Contracts Clause as they should enforce all clauses. But to abstract from the claim that states shouldn't abrogate contracts to the very different claim that the federal government can't force people to buy broccoli or health care is an example of what kind of reasoning? Penumbral reasoning. That is really what Professor Barnett is arguing for, that different constitutional clauses that protect economic liberties create certain penumbras formed by emanations that create a broader, free-floating right to personal autonomy that makes sure that you can't be forced to buy things you don't want. And even Justice Thomas, who is a fierce defender, a principled defender of economic liberty, has in his chambers a sign that says, "Please don't emanate in my penumbras." And I want to suggest that the embrace by conservatives, by libertarian conservatives, of economic judicial activism is the flip side of Griswold versus Connecticut and is just as abstract and indefensible as is Roe v. Wade.
And Professor Barnett will have the last word.
Thank you. The first time in this debate, I'll have the last word. I've been trying to resist Jeff's opportunity to talk about the individual mandate, but he said so many things that are inaccurate about the basis for the challenge to the individual mandate. I urge him to actually read Judge Vinson's opinion. I know he has. Read the briefs, read the arguments that are being made. They bear no relationship to the arguments he's imputing to me and others. I am not, and others are not making arguments based on personal autonomy. We're not basing our arguments based on the Due Process Clause. And we're not basing our arguments on the original meaning of the Constitution. And we're not basing our arguments on broad structural readings of anything. We are basing our arguments strictly on the existing Supreme Court doctrine governing the Commerce Clause and Necessary and Proper Clause. And that doctrine says that Congress may go this far and no farther. It says it may regulate intrastate activity when that activity has a substantial effect on interstate commerce, and no farther than that. It may not regulate intrastate non-economic activity, and it may not regulate intrastate activity, and it may not regulate inactivity, not doing anything. It may not mandate economic activity, something that's never been done before in the history of this country under the Commerce Clause. So it's a straight doctrinal argument. If you want to argue original meaning, well, then we'd have to go back and see what powers that Congress actually has over the insurance business. But Southeastern Underwriters was decided in 1944. It's accepted as precedent by everyone involved in this litigation. And so nothing about personal autonomy or original meaning is what's at stake here. It's simply an interpretation of existing Supreme Court doctrine.
Two words, I can't resist, I'm so
No,
sorry.
no. Both will remain here for questions afterwards. We have to be fair to the next panel. I told you this was going to be a great debate and a great weekend. Thanks to both of our speakers.